Picture this. We've got a modern digital superpower trying to solve complex cyber crimes using laws drafted during the horse and buggy era of the 1860s. It sounds like a total mismatch, right? Well, because it is. Today, we're doing a complete concept mastery session on how India is fundamentally overhauling its entire criminal justice system, leaving colonial-era legislation behind and stepping firmly into the digital age.
So let's just dive right in, shall we? The absolute core of the issue here is a massive technology and governance gap. Laws originally designed back in the 19th century, mostly for colonial control, are really struggling to keep up with modern technology, digital forensics, and just the way society works today. This friction has caused massive delays, confusion, and crazy backlogs in the courts. We really have to ask, can a legal code built for the telegraph era actually deliver justice in the age of the smartphone? Here's our strategic briefing map for this explainer. First, decolonizing the justice system. Then, the BNS redefining crimes, the BNSS streamlining procedures, and the BSA modernizing evidence. After that, we'll weigh the reforms against the risks and finally, lock it all in with some concept mastery.
Decolonizing the justice system. To really get where we're going, we first need to look at exactly what got replaced on July 1st, 2024. The transformation happening here is literally a structural rewrite of the nation's legal DNA.
Think of this as swapping out three massive, creaky colonial pillars for modernized, high-tech counterparts. The Indian Penal Code becomes the Bharatiya Nyaya Sanhita, shifting the philosophical focus from just punishing people to actually delivering justice. The Criminal Procedure Code transforms into the Bharatiya Nagarik Suraksha Sanhita, prioritizing speedy trials and tech. And the Indian Evidence Act is replaced by the Bharatiya Saksha Bill, totally modernizing how we handle digital and forensic evidence.
The whole objective behind these 313 total changes is to finally bridge that massive technology gap. But the bigger picture? It's a complete pivot of the system's DNA. We're moving from a mindset of governing subjects under colonial rule to actually empowering citizens with a justice system that's transparent, simplified, and profoundly faster.
Redefining crimes and punishments with the BNS. This new code actually trims down the sprawling old IPC from 511 to 356 provisions, streamlining things while hitting modern offenses head-on.
A huge shift here is the brand new statutory definition of terrorism. In the past, these offenses were scattered all over the place across different provisions, which created an absolute nightmare for prosecutors. This single, unified definition aims to perfectly streamline how the state defines and prosecutes direct threats to internal security, armed rebellion, and separatism.
And this perfectly captures the dual approach they're taking. On one hand, they are tossing out widely criticized colonial relics, like the offense of sedition, and bringing in things like community service to decongest overcrowded prisons. But on the flip side, they are cracking down hard on modern social menaces. We're talking formalizing capital punishment for mob violence and strict prison terms for deceitful exploitation. It's a really careful balancing act of reform and strict deterrence.
Think of this next mechanism as a literal digital fast track for citizens. Historically, jurisdictional boundaries could totally stall an investigation before it even started. Now, if a crime happens outside your local area, you can file a 0 FIR at literally any police station or even lodge an EFIR entirely digitally. The complaint is recorded immediately and transferred to the right place later. The system now actually bends to accommodate the victim.
Streamlining police and procedures with the BNSS. This is the operational engine governing exactly how police investigate crimes and how courts actually manage trials.
To directly attack those notorious, indefinite judicial delays, the new law brings in a strict, accountable countdown clock. Check this out. Police have to give the victim a status update within 90 days. There is a 180-day hard limit to finish investigations, and once court arguments wrap up, the judge has exactly 30 days to deliver the verdict. It creates a predictable life cycle for a criminal case, which is a real game changer.
Now this right here is massive. Trial in absentia. It essentially means that high-profile fugitives, economic offenders, and organized crime figures can't just stall the law by skipping the country anymore. If a sessions court declares them a fugitive, the trial proceeds and the sentence is handed down, whether they're sitting in the courtroom or hiding halfway across the world.
533. That's the total number of provisions in the new BNSS, and it leans heavily into tech-driven protocols. For instance, it notably mandates the compulsory video recording of statements from sexual violence survivors. This is an absolutely critical safeguard meant to preserve evidence perfectly and prevent any form of future coercion or manipulation during the trial.
Modernizing evidence in tech with the BSA. This is what officially drags India's evidentiary standards out of the 1800s and squarely into the era of cloud servers and smartphones.
The transformation happening here is profound for investigators. The very definition of a document has been revolutionized. An email, a WhatsApp message, a server log, or even a GPS ping is now legally treated with the exact same rigorous framework as a physical signed paper contract. Digital reality is finally matching legal reality.
But, with digital evidence comes the major risk of tampering, right? That's exactly why the BSA mandates super strict admissibility criteria to prove the authenticity of digital data. By setting clear rules for forensic teams and making their visits to serious crime scenes completely compulsory, the law dramatically cuts down the chances of a botched investigation. Plus, it explicitly writes the fundamental presumption of innocence straight into the statute.
Critical analysis, reforms versus risks. To actually master this topic, we need to zoom out for a second. We've got to balance the government's stated objectives against some very real concerns being raised by legal experts and civil rights analysts.
When we compare the two sides, the modernization, the sheer speed, and the tech integration are absolutely undeniable achievements. But the hidden challenge is in the execution. Critics point out that while the colonial sedition law is gone, the really broad new definitions regarding national security could potentially lead to ambiguity or state overreach. There's also the practical worry that overhauling a 160-year-old system overnight is going to cause some major disruptions to established legal precedents.
The real trade-off we're analyzing here is the balance of power between the state and the everyday citizen. Sure, police get sharper tools, like being able to stagger 15 days of custody over a 60-day window to fight organized crime, but critics argue these expanded discretionary powers take a heavy toll on individual liberties. Similarly, letting magistrates collect biometric data like voice samples from people who haven't even been arrested raises some massive privacy questions.
We also have to look objectively at the complexities around these newly introduced socially charged offenses. Take the provision on deceitful marriage promises. It's directly aimed at protecting vulnerable women from exploitation. Absolutely. But critics argue it represents a pretty deep state intervention into personal choices, warning it could inadvertently marginalize minority rights or ignore non-traditional relationship dynamics.
Concept mastery and final revision. All right, let's lock all of this in. This is a high-density recap designed purely for memory retention and structural understanding.
Take a mental screenshot here. These 5 takeaways synthesize the whole legal overhaul. 1. The foundational shift from IPC, CRPC, and Evidence Act to BNS, BNSS, and BSA. 2. Moving from colonial punishment to tech-driven justice. 3. Those strict new countdown clocks for investigations and verdicts. 4. The institutionalization of EFIRs. And finally, 5. The main analytical risk, balancing those faster trials against expanded police powers.
To really articulate these systemic changes, you've got to have the right vocabulary. Trial in absentia stops fugitives from freezing the legal process. Zero FIR empowers victims beyond geographical borders. That 15-day custody shift is your prime example of expanded state power. And electronic evidence proves that a digital footprint is now just as legally binding as ink on paper.
I'll leave you with this final thought to ponder. We've seen the incredible technological upgrades and the commitment to faster timelines, but we've also seen a real expansion of investigatory powers. So, does this new framework successfully pivot the nation from colonial punishment to citizen justice? Or does it inadvertently give the state way too much discretion? How we answer that question in practice over the coming years is going to define the future of India's democracy. Keep analyzing and stay curious.